Thank you and good afternoon. Hope I'm able to arrest your attentions after this lunch. So the topic is with respect to real estate. Real, the name suggests something real, physical, tangible. So anyway, uh, just to catch up a reference from the last budget, there was a parliamentarian who was making a statement in the parliament that the provision for slashing of LTCG rates from 20% to 12%, 12.5% has something to do with the tax relaxation or something. Parliamentarian then said that actually doing away with the indexation has created a havoc rather. Instead of taxation relaxation, it has actually gone to make the taxation triple. So I'm just relating it with respect to the legislations coming down on the real estate and effects thereof. So to begin with, we have our Neeraj sir, senior advocate, and sir, immediately after the inception of this IBC in 2016, this legislation, I mean the implementation of this IBC on the real estate has saw a lot of judicial legislations, which was followed by ordinances, then followed the parliamentarian actions of legislations, then rolling down. Your views and overall views with respect to the journey of immediate, quick succession, legislations coming up in quick successions, maybe judicial or legal. Your views on this, sir.
Thank you, Jyoti. So, the changes in the real estate sector pertaining to the IBC have been, I won't say have been too many, but yes, few but substantial. So, after the promulgation of the IBC, the first change pertaining to the real estate which we witnessed was the inclusion of the home buyers in the definition of financial creditors. Now, this was actually brought about in view of the I would say the dilemma as to whether to treat these home buyers as under the category of financial creditors, as has been defined under the IBC, under subclause 7, or to bring them under the definition of operational creditors, which is in terms of clause 20, subclause 20 of section 5. So, obviously, the judgment of the Supreme Court, Sharma, and then the committee which was formed of one Mr. Srinivasan, pursuant to which it was recommended in terms of the report of that committee, that looking into the aspect of the manner of financing which is being done, or the payment which is being done by the home buyers, they should be brought into the domain of a financial creditor. And thereafter came the inclusion of the home buyers within the definition of the term financial debt in terms of subclause 8. And they were given this tag of financial creditors. That was the first one in 2018, which actually, wherein this aspect of real estate related IBC actually emerged. That was the first major, I would say, the change. Now, this was challenged, this inclusion was challenged by some stakeholders or otherwise, whatever you would call them. And this issue was also set to rest in the case of Pioneer by the Supreme Court. So, the Supreme Court actually held that they, in terms of the definition which was given to the explanation of Section 5, Subclause 8, there was a deeming provision added. In terms of the deeming provision coupled with that explanation, they said yes, that's valid. The amendments are valid and they will be taken to be as financial creditors. So this was in 18 when it happened. The subsequent event which happened post this is obviously, I would say, a kind of a fallout of this inclusion of the home buyers within the definition of financial creditors, is that the changes which were brought about in Section 7, wherein the concept of the class of creditors, or you would say the creditors in a class as they termed it, in which situation could they initiate a CIRP. So in terms of that proviso which was added to Section 7.1, the limit was put to, or I would say the threshold was put to 100, minimum 100 creditors in a class, or minimum 10% of the creditors in a class, so as to initiate a CIRP. That was the first proviso which came in, and obviously it was a fallout or a consequential action of the amendment of Section 5 subclause 8, getting the home buyers into the aspect of within the definition of the financial creditors. The second proviso which came in terms of Section 7 subclause 1 was that when it comes to a real estate project, then the threshold limit was set to 100 allottees in a particular project, or 10% of the allottees of that particular project. So there, following that amendment, a threshold is set up that in case you want to initiate a CIRP vis-a-vis a real estate project, then this is the minimum threshold you have to have. And obviously, with this threshold being set up, then the other allottees of the project would also be bound by it, because then these are the financial creditors in a class, so the other class is automatically bound by it.
So would that mean that first, as per Supreme Court judgment, the definition of home buyers was widened enough, and then there was a attempt to control it by fixing the numbers?
Yes, actually, what Pioneer said is that they were always there in the class. They were always financial creditors. It's just an explanation. Therefore, it will be given a retrospective effect. So they say because of the deeming provision, they were always there. It is an explanation added. Explanation would mean that they were always there. We are simply explaining. Therefore, you go back to the state having the retrospective effect. So it's not an amendment in the sense that an amendment would act prospectively. Amendments are all prospective in nature, but deeming provision, they said that, I think Justice Nariman said it's retrospective. Obviously, the challenges were there. They were made, and they said no, it's not in violation of Article 14, 19, 21, Article 300A of the Constitution of India. Now, the threshold limit having been raised, now the issue was, it in a way turned into a REM, in the sense that supposing I am an allottee of a particular project, I don't want this to go into CIRP. But because 100 allottees have already gone, the threshold is met. Now I am also bound. So it in a way turned from a persona to a REM. So other creditors in a class, being the allottees, are bound by it. So that was the second amendment, which again came to be challenged. All amendments, all provisions, the minute they come, there is a challenge, whether by the home buyers, by the real estate companies, or whatever. Now this also came to be challenged in the case of Manish Kumar, and there again the validity of the proviso which was inserted in Section 7.1 was upheld by saying that actually what one allottee could do earlier, now only a minimum of 10% or 100 allottees can do. So it clarified, it's raising the threshold limit. Instead of a single person initiating the CIRP, Now it's, you need a minimum threshold, like you have in I think 397, 398, the erstwhile Companies Act, or 241, 242, minimum 100 number of members you need. So that was the second, I would say, change pursuant to the inclusion of the home buyers in the financial creditors. So Manish Kumar upheld that. And Manish Kumar also said that in a way this has turned into a proceedings in rem, because other allottees of the project who don't want the CIRP, they also get dragged along with it. So this was the second change which happened. While this was happening in 2020, I think Manish Kumar is 2020, came the judgment of Winter Hills, which is the I think Umang Real Tech by Justice Mukhopadhyay. Now that for the first time brought in two very substantial, I would say draconian and very innovative changes. Where first the concept of reverse insolvency it originated in that from that judgment. The concept of reverse insolvency and the concept of project-wise resolution in the same judgment. The beauty of the judgment is it contained both these aspects, and the trigger to Winter Hills was Swiss ribbons. If you recollect, Swiss ribbons, Supreme Court basically nudged the NCLT and NCLAT that when it comes to these economic related matters, there has to be some more innovation. So the nudge to do something different, or maybe have a practical approach to the CIRP process vis-a-vis a CD who is a company, a real estate developer, juxtaposed with the projects. Maybe a builder has 10 projects, maybe a builder has 1 project, or a builder has 20 projects, like let's say Supertech. Now Umang Real Tech was, I would say, one of the classiest cases or judgments pertaining to the aspect of a judicial legislation. It's actually a judicial legislation where the judiciary has stepped into the aspect of the legislature.
Which is yet to see actual legislation.
Which is, till now, till date, it's yet to see an actual legislation. And the Supreme Court has given it a stamp of approval. Not in one case, in various cases. So Umang brought in the concept of reverse insolvency, bringing back the debtor into control, which is, I would say, an antithesis of the IBC, which should be the creditor in control. Now, reverse insolvency, I think everybody knows, I don't need to stress upon that what actually is it, but the same promoter who is otherwise barred under 29A to put in a resolution is brought back. So debtor getting back into control, you have defaulted, no issue, we'll give you another opportunity, another lease of life to you, act as a financer, don't be a part of the CRP, stay away, but pump in money. So the debtor comes back, gets in the funds, maybe by Swami fund or whatever the funds are now, distress assets now that Swami fund is taking shape nowadays in practically, I think 2 out of 5 cases which I am doing, there is a Swami fund which comes in. And other, whatever the funding sources are. So the promoter gets back into the control, otherwise could have been barred under 29A, finances, and then takes the project ahead. And the reasoning or the logic or the raison d'etre, as they call it in law, for permitting this is, in terms of Umang Real Tech judgment, that it will ensure a speedy completion of the project and maybe give employment to hundreds of workmen. This is the wordings used by NCLAT. Nonetheless, so a judicial legislation, maybe judiciary stepping into the domain of the legislature, killing the principle of the segregation of powers. That is anyway one aspect. Plus 29A being breached, creditor in control taking a back seat, debtor in control coming in, and proceeding with the reverse insolvency. But we have seen a lot of cases going ahead. I mean, there's a lot of cases. This was one case followed by Rajesh Goel, Mamta Gupta, and then came the other cases. I think of the Supreme Court also. If I'm not mistaken, it's Sony Infratech. If I'm not mistaken, it's I think Sony Infratech, which again endorsed or gave a stamp of approval to the aspect of reverse insolvency. So reverse insolvency has been there since 19. It has taken flight. So this was the aspect which came in of reverse insolvency, and now comes the other part, because again this aspect of project-wise insolvency had started through Umang. So that also took wings post Umang, and then it started that let there be instead of a complete insolvency of the entire CD, vis-a-vis the projects which are doing well, where possibly there is no CIRP initiated by any of the allottees. So see a situation where there are 10 projects, out of which, let's take the example of Supertex. Supertex is a classic example. In the case of which had gone to the Supreme Court, India Bulls versus Ram Kishore, that is I think the name of the case. Now they had several projects. Supertech had several projects, and one of the projects, Eco Village 2, the CIRP was initiated by some of the allottees in terms of the threshold limit under Section 7 pertaining to that project. Other projects possibly they were going strong, so there were no CIRP initiated in respect of those projects by the allottees. Now a very unique order is passed by the NCLAT, which is upheld, and I would say very logical, a very practical view taken. Again, we are keeping the aspect of judicial legislation aside. We are dwelling on something else. There they said, the Supreme Court said that, see, vis-a-vis Eco Village 2, which is in respect of which CIRP was initiated, we will have a COC. COC will be formed vis-a-vis that Eco Village 2. It will proceed. But as regards the other projects, that again will go through the route of reverse insolvency, where the promoter will come, he will get in funds under the guidance and management of the IRP, not the RP. Because you can't logically form a COC in a reverse insolvency, logically. So that aspect is another thing which I'll come, how all these provisions pertaining to Regulation 36, 36A, 36D, Information Memorandum and RFRP and Form G, everything is given a go by. So they said Eco Village 2 COC will proceed. The other projects need not be brought into the aspect of CIRP. They'll be under the guidance of the IRP. Project funding by way of reverse insolvency will be brought by the promoter. There'll be a kind of an informal committee set up of 3 home buyers, 2 promoters and 1 IRP who will manage the other 8 or 9 projects. So this was again, Supertech is again one of the very unique cases where a COC is proceeding against one project, other projects are not being affected in a way. IRP is taking control, but reverse insolvency is way. And one more thing, just to go back again, in Umang Real Tech, what Justice Mukhopadhyay said is that when he floated or conceived this idea of project-wise insolvency, he said, see, the allottees of other projects which are not being affected will not be able to file a claim in respect of the other project which is under CIRP. So therefore he created a distinction that simply because you are an allottee or let's say coming under the CD, the company, but belonging to a different project, you will not be filing a claim in respect of the project in respect of which the CIRP is there. So therefore in 19 that distinction is created. Projects are separate, CIRP in respect of one, COC only looking into the other, IRP for the other ones. So Supertech is again one of the most, I would say, ingenious cases which has been set up where partly CIRP and partly reverse insolvency with the same CD. So this was where the aspect came in. And lastly, not to take too much of time, now the amendment of 2024, I think February it has come in regulations, the corporate debtors regulation, I think 36A, where project-wise resolution plans are being called for. So that's a further, I would say, a kind of a delineation of this aspect of project-wise insolvency, that there could be 6 projects and maybe under a same committee of creditors, but the resolution profession will be allowed to call for different resolution plans for different projects, again to affect a speedy resolution of the disputes. So these are the major changes which have happened. I would say in the last 6 years, I would say not too many, but it's good in a way, but substantial changes with a view primarily to ensure that the home buyers are able to get their flats. Instead of the company or the whole company going into CIRP or subsequently into litigation, just because one project is faltering or it's in default, the other projects need not be harmed. So these are the changes which have happened. Now, the aspect, I'll deal with it later, maybe now on some other occasion, that whether this reverse insolvency, especially this aspect of project-wise resolution, not being mandated by law, it is still being given a judicial stamp of approval, even to the extent of the Supreme Court, going ahead and especially passing this judgment in the case of Supertech. And coupled with the fact that in a reverse insolvency, you are completely bypassing the provisions of the IBC, starting from the formation of the COC till calling of the information plan, till publishing Form G, then going ahead with the RFRP, and then a resolution plan by third party. So everything has been kept at bay, kept aside, and this concept of reverse insolvency has now come up. And surprisingly, till date, I don't know why, despite the multifarious judicial pronouncements on this aspect, even up to by the Supreme Court, the legislature hasn't stepped in to give it I would say, a legal shape by way of an amendment in the IBC.
That's really very informative. And Manish sir, before I come to you and have your views as an insider and somebody who is looking from inside and getting affected, before I come to you, let me have a few views with respect to this reverse insolvency. There being lack of legislation and there being lack of structured position as to if reverse insolvency is initiated, who will take control of it, who will report to whom. So Jitendra ji, starting from you, and then Nilesh ji and Ankit ji, your views on practical aspects, like COC usually have their creditors only who are there to recover their monies. Do you feel, constraints when it comes actually the implementation of the real estate development? And your views on that, like one view is really getting oscillated these days, that debtors in position, in control need be brought back. Your views on that aspect?
You see, I really believe whenever we talk about insolvency, we talk only about resolution. But whatever the creditors are involved, they are concerned only with their recovery. This is a clear fact, but nobody wants to say it openly in the court, in whatever discussion, but everyone is concerned with their recovery. We have seen in the COC, nobody is willing to discuss on the feasibility and viability of the project. Nobody is willing to see whether the structure which has been there since 10 years, whether it can withstand a new development, a new RA coming in, developing the building. So whether it is technically viable, because the plinth level all are exposed to environmental hazards without upkeep and all. So we have seen in many cases wherein the RA coming in, inspecting the building, and they are concluding that yes, this cannot be redeveloped. So the erosion in the money has already happened to a maximum extent. Now coming back to the relevant judgments where even the Supreme Court has given the stamp of approval, which says that there cannot be any haircut to the home buyers. So when we talk about RERA, so RERA takes care of only about the interest of home buyers. So what about the other stakeholders? So if you see the insolvency cases, mostly has been triggered by the individual unsecured financial creditor. Because it's very difficult, 100 home buyers getting together or 10% home buyer getting together and filing an insolvency application. So it's a forced insolvency to the home buyers. And this regarding this debtor in control model, I mean, I don't believe that, and even this reverse insolvency, as sir has rightly said, that it's a judicial legislation, although given a stamp of Supreme Court, but it's a case-to-case basis which has to be looked into. It cannot be legislated. If you see the last discussion paper, which was based on the committee report, it discussed on all the aspect of the previous judicial pronouncement on the reverse CRP or the insolvency, but still did not touch upon it. They simply amended the law saying that you can do project-wise insolvency. It was always there. If you see the regulation clearly says that you can have resolution plans. When the regulation says you can submit a resolution plans, it doesn't mean a single plan. There could be a 2 resolution plan for one corporate debtor. It was always there. We have done way back in 2018, tried to, combine 2 resolution plan and then present to the COC and then file with the adjudicating authority. At that point of time, everybody says, no, this cannot happen. There has to be a single plan. But it was always there in the law. And then there was an amendment which says that, clear amendment, now it is there in the law, which says that there can be a resolution plans, more than one resolution plan for a corporate debtor for resolution as a whole. Now, debtor in control model, then this is, as sir has already said, this is not the intent of the law. When we have to understand, IBC is a deterrent. We have to take it as a deterrent. When the promoters or the developers have a great fear of losing the control of the company. It is their greatest nightmare. You see, I am RP in many cases. I avoid rather taking a chair of the promoters going to their office, removing them from chamber. So I sit opposite to them. Look, you are the boss, but I am the boss of IBC. You have to listen to me. But it's not a way that you remove him from the chair. You hit him very badly, his ego and all. You have to work with him. You have to deal with him. When the company is going concern. So the debtor in control model has to be a deterrent. This reverse CRP might be good in cases wherein maximum of the work has been completed. Like in winter case, basically, the project was almost complete. And there was some fit out pending, lift pending, some sort of work were pending. So there it can be possible. But in a project where 50% of work is completed, the project has been incomplete since last 5 years, 10 years. So no salvage value has been left for any RA. There has to be a haircut. So if we bring back the debtor in the position, so it will be insolvency will be devised taking in benefit of the moratorium, where section 14 moratorium is used by the same promoter who had diverted the fund. No real estate project could fail, in my understanding, because that is built on a certain principle of prices at that point of time. So you fix a price for a particular flat, considering the cost of material and the land. So why the failure is there? Maximum failure has happened because there has been diversion. You take a money from one project, invest in certain other project. So that sort of comfort should not be there. I know that for the real estate sector, it's a long go before we can achieve success in insolvency in the real estate sector. But it should be a last resort. And it should be there that you will lose the control. Because when we talk about real estate sector, we only talk about the cases which are either undergoing insolvency or undergone insolvency. There are many cases which has been resolved even prior to invocation of the CIRP. Because of the debtor settling the claims, because of the debtor settling with the creditors, either the home buyers or withdrawing the CIRP. There are many cases. So we have to see the success of these cases. And it was there only because there is a fear of company being snatched from the promoter or the developer. The PIRP experimentation has been done, but it has failed miserably. So the debtor in control model was always there through BIFR, SICA, or maybe through SURFACI action. Debtor was always in control. So why you see, he again be allowed in the insolvency regime to continue with same sort of control, same sort of power. There will always be a tussle. You see, when the IRP or RP is there, how do we say that a particular expenditure is genuine? He will produce an invoice. Now what you will do? Along with the supporting, and then you have to approve those invoices. He will always try to take out the money from the project. How do you stop him? There will always be a trust deficit. There will always be a means by the promoter that how he can benefit. Because if he's putting money from some third party or from third sources, he is doing only to benefit himself. When he is not a saint that he will be trying to complete and give the hand over of the flats to the home buyers, just because of that he is willing to fund. So he will definitely try to make money out of it. And there is a problem when the money from one project goes to the other project. So when we talk about reverse CRP in one case, when we talk about full CRP in other project, how do we deal with it? I have been into one of the CRP cases. It was basically spanning across 3 companies. So we tried to do group insolvency, combined all the 3 companies, because in Bengal, there is a ULC, Urban Land Ceiling Act, wherein you cannot hold more than 25 acres of land. So we combined all the 3 companies and handed it over to the allottees by forming their association. But still they could not do till date. They could not resolve this, although having all the resources and all, everything under their control. So yes, IBC might not take care of the real estate in a way that it is resolved to the desired result, but there should be separate mechanism, I believe, maybe under RERA, wherein the interest of all the stakeholders, not only the home buyers. You see, the bank has also funded. Just now Ankit ji has shared an article in the WhatsApp group wherein it was saying that a rich man has funded a money to a rich man. The rich man is called a bank. So bank has funded a money to a bank and the home buyer is being harassed. But at the end of the day, you have to see that bank money is our own money. That has also to be protected. The ecosystem of financing has to be protected. There are no project finance. Why Swami Fund is coming? It's a stress fund under State Bank of India. So why nobody is funding? It's a red flag for the real estate funding nowadays. Even for the big players, they do not want to fund the real estate project. So the ecosystem of funding has to be maintained. The home buyer, the home is a very emotional issue in India. But not all home buyers are, you see, the first home buyer. They are investor. They already have 3 or 4 home and already owned 3 or 4 homes. So this might be their 4th home as an investor. The big project we talk about is a crores of flat. So that's
so to sum up, you say that so far as reverse insolvency is considered, it has to be applied case to case basis only. Depending upon the project completion stage and all. Nilesh, you have your views on this, and then you also have certain views with respect to authorities' dues being the largest one, and the authorities being hurdle with respect to one of the pain points for the IPs.
Right. First of all, regarding this reverse CIRP or reverse insolvency, so as we know that earlier we were having that SICA regime, and under SICA we were having the debtor in possession, and now under IBC we have totally shifted to creditor in possession. So I think this reverse CIRP or reverse insolvency is a mechanism where the existing promoter, he gets a chance to make efforts to see that if he can revive. He can revive the business of the company. He can complete the construction and all that thing. Otherwise, if you see that the existing promoter has been totally thrown out, he's not there. Section 29A is there, because of which we say that no, you cannot participate. And but I believe as a professional that existing promoter is the best person. So I'm not saying that all of them, many of them, they have different intentions, they have siphoned away money and all. But I think otherwise, many promoters have been there which have suffered because of reasons beyond their control. Many CIRP cases I have seen, especially in real estate sector, where what has happened is that the construction is going on, but still some delays have been there for different reasons. And the home buyers, they started filing applications before RERA authorities, they started filing complaints before consumer forums and all that. And from there, they were getting orders for refund. And when a number of orders were issued earlier, I think interest rate was also, which was being awarded, was very high. So what has happened is that promoter, he has to refund the money to them, and as a result, whatever working capital he is having, that is totally exhausted. So now what is to be done? So in this type of a situation, then promoter is not having anything to do. His only thing is that he has to allow the company to go into insolvency. And when insolvency starts, now, Honorable Ankit has allowed this thing to happen. They say that, okay, existing promoter, you do the construction and arrange the necessary money, and with the help of the same, you do that. So I think one benefit which is available to him is that the moratorium is available. Because CIRP is going on, CIRP is there, the formation of COC is stayed by Ankit. And even presently also in a number of matters, Honorable Ankit, they are staying formation of COC, and they are allowing the existing promoter to arrange the money and start doing the construction. And I have seen a number of matters are there where this type of thing is working. Promoters, they have arranged money, and now at least they are having that chance. You know that earlier there has used to be this restructuring of the dues. That is not there presently. If you fail, then you have to be thrown out, because this insolvency thing is there, and there will be one application which will be filed. But earlier we were having provisions for restructuring. So existing promoters were also getting some chance to revive the business. But now, you know that with effect from 2015, change in RBI guidelines were there, and they said that once a restructuring is made, the account has to turn into NPA. Though earlier, the provisions were that under certain circumstances, the account was allowed to be continued as standard. But now it is not there. So as a result, banks are not interested in restructuring. So once you feel some temporary difficulty, and because of which your account become NPA, then you have to go out. So I think that type of situation should not be allowed to happen. I think there should be, if this type of difficulty is there, that for some period of time, market conditions are not good, or for some other reason, you are not able to continue with the business, then in that case, I think there should be some provision for restructuring, and existing promoter also should be given some chance. Otherwise, what we are doing, we are allowing outsiders to join or to come forward for taking over of the business and making huge amount of money. They are also joining here for what purpose? For making money. So it is not in the interest of all stakeholders. So they will be coming, they will be asking the existing home buyers to contribute further amount, and they will be making good amount of money out of all that. So existing promoter, we are throwing away, and we are saying the others, you come forward and make money out of this. So this is one thing. Second is, so in this way, I feel that an opportunity is being given to the existing promoter, which is good. But at the same time, problems are that the total, there is no clarity about this process. RP is there, IRP is there, CIRP is going on, formation of COC is state. So now the control has to be with the IRP. He is the custodian of the assets, but you are allowing the existing promoter to run the business, who will be signing the checks. So we have to become joint signatory along with him. But can we stop him from making payment? But who will be identifying the contractors? Who will be purchasing the material and all that? So we become party as IRP, but we are not having full powers relating to the same. And what will be the final fate of this? So this will be continuing for some period of time, but at the same time, during this period, other creditors are suffering. Suppose some bank is there, he is not getting anything. Suppliers are there, they are not getting anything. So this problem is not this is not the complete solution. Ultimately, there has to be a resolution plan which has to be formulated, and then as per that, the different stakeholders will be dealt with. Okay, so if I continue this process for a period of 1 year, 1.5 years, or 2 years, and suppose I have completed some of the towers, but there are still other towers which have not been completed, and then how we will be making payment of other creditors? So what will be the end of this process? I don't think there is a clarity, and it is not the only purpose of this process to build some of the homes and then rest of the people suffering. So I think though it's a good thing, but at the same time, there has to be a change in law, in the regulations or IBC, where the complete process has to be defined, and who will be, the clarity has to be there with respect to different things, like whether board is suspended, who will be appointing auditor, suppose auditor is not there, and a number of other questions are there which are required to be answered. So I think there is a need that complete clarity is given with respect to this thing of reverse CIRP, and then after that, I think the objective of this particular process can be achieved.
Well said. Ankit, coming to you. Your views also with respect to reverse insolvency, and in addition to that, since you have a lot of experience with respect to running the insolvency proceedings, the difficulties you usually face, I mean, your practical experiences with respect to like gaining supplies, gaining services, and difficulties with respect to raising of money and all. Your experiences and views, practical views with respect to that.
So, reverse insolvency, then we have different stages that we talked about. I think the latest stages that have come in are the Greater Noida versus the Paramjit Soni judgment. Then, of course, this recent judgment, 2 weeks back, Supreme Court gave a judgment with respect to subvention scheme, telling all the home buyers that based on this judgment, there will be no adverse implication on you, and you don't need to pay that amount of installment to the bank, where the bank had financed the home on a subvention scheme. What is a subvention scheme? Subvention scheme is typically an agreement, a tripartite agreement between the builder, the borrower, and the banker, and where the banker pays to the builder bears the interest for the first 3 years, and the borrower is the home buyer is the primary borrower. So the loan is taken in name of the borrower, but at the same time, the beneficiary for the amount that is coming in is the builder. So that is what I think we were also talking about. Rich man, that is the builder giving money, rich man, that is the bank giving money to a rich man, that is the builder, and the poor home buyer who might be funding this entire home from his salary is continuing to pay installments without a home in sight. So Supreme Court gave relief in those cases. Previously in Paramjit Soni, Supreme Court gave relief to Greater Noida Authority, saying that no, you are also a stakeholder. And before that, we used to think that home buyers are also, no stakeholders. So it started with the regime where we said that, okay, the banks used to believe, we have had those meetings as AAA when we used to go over home buyer cases, they used to say, we are the only financial lenders here, we will give nothing to the home buyers, we will give nothing to the landowners, we will take everything away. This is what insolvency is for. So we are financial creditors, we will sanction a plan which gives everything to us and nothing to the home buyers and the landowners. Then came all this litigation and home buyers got a status. So home buyers and financial creditors together said that, okay, we'll keep everything for ourselves, whatever is left we'll keep for ourselves, and we'll give nothing to the landowning agency. Now we have another judgment where again landowning agency is identified as a secured creditor, if not a financial creditor, a secured creditor, and it also needs to be taken into account with respect to this balancing act. Now, when typically a real estate project starts, we need to understand how it starts. Somebody has the land. That somebody who has a land can be industrial authority or a government body like Greater Noida Industrial Development Authority, or it can be a private landowner. There is a builder who has some reputation in the market to build some flats, who can use his name to sell those flats in the market. And there are, of course, home buyers. Home buyers are again a mix of those people who might be using their entire life savings to build their first house. There also might be many people who are simple investors who have seen a boom in the real estate, who feel that today I only need to pay 10% for this home, and after 3 years, 2 years, it will become, this 100 rupees of value that I'm buying this at, it will become 120, so my 10 will become 30. Because 100 is becoming 120, so my 10 will become 30. So it's a 300% gain overnight within a few years. So this is how, this whole system works. And then, of course, when the project goes bad, the project can go bad because the promoter was not experienced enough. There was losses in the project. There were delays in the project. Construction cost went up. There might be possibility that the land that was being paid for was not the only cost. There was a requirement to pay for land over and above the cost that is on paper. So there's so many situations which we can fall into. But today, when we talk about a project in distress, the idea is to look at all the stakeholders, understand what is remaining. What is remaining can be unsold inventory. What is remaining can be also a delta with respect to what was the rate at which the home buyers booked the flat and what is the rate in the market today. Because in case home buyers, we talk about haircut, their haircut can be that, okay, they can say, we want a flat. We booked at 2,000, we only want the flat at 2,000 rupees. But what are they getting after getting the flat in their hand? Maybe they're getting a flat which is not costing 2,000 rupees in the market today. Maybe it is costing 6,000. So in case we ask them that, no, don't pay 2,000, pay 4,000 and you will still make 2,000. Maybe that's a fair position. Similarly, you to go to the bank and say that, okay, you had lent 100 crores for this project. You had security. Maybe you mismanaged your security. The builder went away or went along and sold way more flats as compared to the security that was with you. Because there was not supposed to be this double funding on a project, right? How do we double fund a project? The builder says, I have 100 units as in my inventory. I have sold 50 to home buyers. 50 I am pledging with the banker and I'm taking a loan for construction of those 50 from the banker. This is what typically happens. But in many cases, what the builder has done, he has taken funding from 50, he has also sold 25 out of the 50 to the home buyers. So he's done double funding. Now in those situations, if there the bank has not been observant, double funding has happened, there again there can be a higher discount on the financiers because they have not been observant. Then landowning agencies, in case they have not been paid in time, they are also a stakeholder. They also need to take a haircut. So far, when we have interacted with one of the cases, court said to us, you go to the CEO of Greater Noida Authority and you negotiate. And we sat on the table, we sat with the CEO of authority and we said, okay, we want to negotiate here. They said, their answer was that we can't give a rupee of discount. That is how we can start the negotiation. So we said, okay, so there is no negotiation. We go again to the stalled project. So the reverse insolvency when it starts is a result of frustration that insolvency is not bearing fruit here. So many years of litigation has already passed by. So I understand that nobody in the country, no banker, no government feels that the creditor in possession has not worked for the economy, has not worked for the banks, has not worked positively to create a fear amongst promoters that if we are not keeping our debt in control, if we are not paying our creditors in time, our company can go away from us. The examples of Bhushan, SR are examples where companies have gone away. Good companies, they have created with a lot of hard work, with their sweat and blood, and then, that has gone away from them. So this is supposed to remain. I don't think debtor in possession in the long run is going to bear fruit in India, especially when even in creditor in possession, we have so much struggle in getting information, taking over a project, trying to create a market for that asset, which is fair for the lenders. We cannot, if you imagine that, okay, I'm supposed to, if I tell you that, okay, I have a property which I'm wanting to sell as a liquidator, but I don't have possession of it. My guards are not protecting the property. It is the promoter's guard who are protecting the property. Will you be interested? But the moment I tell you that, okay, my guards are there, I have complete possession of this property, I have complete title of this property, now are you interested in this property? That will bring the attention from the market that this asset deserves. Similarly, in real estate case, we had a case, Puma Developers. It's a successful resolution case where there was no land dispute. There was only, the home buyers were there, the project was still feasible because the unsold inventory was still much, and we had a resolution applicant. He has now completed the project, handed over all the units to the home buyers. The litigation that we go into with all these projects is what is creating these delays, creating this frustration, which we need to end with creating a balance between all the stakeholders. This is my opinion.
Thank you, Ankit, for your views. Manish sir, now coming to you, sir. Very valuable views of yours. This CIRP initiation, since its inception, I mean, immediately after its inception, it has seen application of CIRP against big names, JP, Amrapali, Supertech. I mean, is it there something which is beyond mere debt default? I mean, there can be many causes. Your views on that? And yeah, is there? I mean, what is the perception? I mean, is there a restlessness or something? Is there change in the mindset after this CRP commencement against these big names, big brands rather? Your views.
Thank you. After all that has been said by so many luminaries, there is almost nothing which is left for me to speak. The question paper was leaked. The answers have been written by others, has already been said by others. So I was told it was open book question answer, but here I feel cheated. Everything has been answered. And that being so, my brother Madan Sahab is joyfully having the last laugh. So what I'm saying is that what I want to know is that why is the home buyer so important? Why is a class by itself? What is so special about him? Why are we sitting over here? Why have we created exception? Exception is becoming bigger, greater than the law, or exception is perfecting the law. No law, no principle is absolute, and only the exceptions perfect the law. So what has happened? While I was doing this, a song was playing in my mind. How many of you have heard the song called "Tumhe ho na ho, mujhko to itna yaqeen hai"? Anybody who's heard this song? Huh? और दो दीवाने इस शहर में. हाँ. So that was a movie called Gharonda. And insofar as the central plot of that movie was concerned was that these two very young people who are in Mumbai, they work in the same office and fall in love, and they want to have a house of their own and start a new life. Both of them pull in their savings and then they sing songs, and this money is paid to the unscrupulous builder, and the builder runs away. The flatmate of Amol Palekar commits suicide, and ultimately they don't get married, and that's the story. IBC was not there, nor was the reverse insolvency. So therefore, whether it is good or bad, now this movie was in 1977, immediately after the emergency. So you can realize the Bombay of that time, and if you see those songs, and it's that there are two pairs of songs by Gulzar, very beautifully written, Do Diwane, and then Ek Akela is Sheher Mein. So that is how brings that is the background in which, and if you jog your memory even little back, you'll go to a movie called Shri 420. Of course, now 420 is not there. One of the central plot of that movie itself was that insofar as this, he was selling plots for ₹100. So owning a house is a very big dream. So therefore, globally, insofar as the housing sector is concerned, it fuels the economy. We fuel around about, in some estimates, 10% of the budget. The 10%, not the budget, but the overall economy is run by real estate. And most of the people, many of the people over here, if you look at your parents, the only saving they would have had was a home. So after working for husband-wife working, or husband working for getting their children educated and married, all that they were left with a home. So it's a very sentimental issue. And that is why economics and sentiment sometimes don't go hand in hand, and that is how we have created this problem insofar as exception is concerned. I'm just relating to you and why real estate is important. So don't catch me by a few billions here or there between friends. It doesn't make a difference. All the real estate in the world, if you were to value it, and don't ask me how it is valued, but that's how Google and other sources tell me, it's around about $300 trillion. The total amount of stock markets, the US, all the five top stock markets, all the listed shares in the world, if they were to be put together, they would put to be around about, depending upon which day you are on the market, it will be around about $110 trillion. And if you were to put the entire, let's take for instance the gold, put together, it will be around about $21 trillion, insofar as the whole of the world is concerned. Insofar as bonds and other debt instruments, which are debts which are traded and things of that which we are talking about, is another $100 trillion. And the total debt, secured, unsecured, government debt and things of that nature would be around about $300 trillion. Out of which this entire quadrillion dollars would be the entire size of the money that we are all talking about. And sir very rightly said that ultimately it's all about money. Everybody wants to recover as much money as possible. So when we look at this entire structure, and insofar as the Indian is concerned, in India you will see the middle class who benefits the most, pays the most taxes and makes the most amount of noise. The entire noise in the system is controlled by this middle class, and this house is a very big asset. So therefore, I'm not saying, I'm saying to everybody who's going to buy a house or things of that nature, when you buy a stock, when you buy a bond, when you go to a mutual fund, it is very boldly written over there that it is subject to market risk. Why did the home buyer forget about this? If there is no possession, you'll have to pay more, buy a smaller house. Why did you not do it? Insofar as this risk and this haircut is concerned, so larger the gain, the larger the risk, the larger could be the thing. Today the government has stepped in, and insofar as the efficiency of this entire system is concerned, Jyoti was telling about that how important insofar as the housing market is concerned and this home buyer is concerned, and there was a Raghav Chadda was the one who was actually speaking about the capital gain and the indexation part of it. Now that apart, but if you were to look at it today insofar as IBC is concerned, with all its failures and flaws, there are two documents which have come last week. And one is the budget, we all know, and before the budget, 2 days before, another document comes which is the economic survey. Both these documents have, budget is 2 paragraphs and there are 3 large paragraphs in the economic survey insofar as this IBC is concerned. I'll just take the liberty of reading it out, since I was told that it is also not only a question paper was leaked, but it was said that it was open book as well. So I will not trust my memory and I will read what is written in the budget. What the budget says, you can stop me whenever you get bored, or you can clap, I'll stop. Huh? It's very dangerous to give mics to lawyers. So what does it say? In the morning we were talking about something which was called, and this is in the Union Budget, para 59 onwards, an integrated technology platform will be set up for improving the outcomes under the Insolvency and Bankruptcy Code, IBC, for achieving consistency, transparency, timely processing, and better oversight of all stakeholders. So that is the platform that in the morning the gentleman sitting on the second seat was speaking about. Insofar as that platform and the government is putting some kind of a money, I hope the lawyers also adopt technology. And once it's adopted, and there is another para, I'll skip the 16, but the 61 is even more important. So what IBC has done, I'm talking about what is done in the courts is not important. What has happened outside the court is even more important than what has happened in the court. Once a matter comes before the court, then it gets caught within the quagmires of procedure and law. And whether it is right, as sir pointed it out, that insofar as a purist you would not like insofar as the reverse insolvency is concerned, but as a practical I think it was best, and I was even more delighted to read the judgment when I read Shweta's name as well. So I didn't miss that. So I've read that judgment. So 61, what does it say? These are 2 very, very important paragraphs, and what Ankit had said, that insofar as the balancing is concerned, what is the objective of IBC and what it has achieved? It is staggering, and this is why insofar as the banks in India are today solvent, as a result of which the banking system, if it becomes insolvent or becomes weak, then interest rates will rise. Once interest rates will rise, inflation will rise, and ultimately we will not be sitting in such posh places to attend such conferences. What does it say? The IBC has resolved more than 1,000 companies, resulting into direct recovery of 3.3 lakh crores. This figure is not very important. The second one, which is important, crores from the creditors. In addition, 28,000 cases. मतलब IBC का डर IBC से भी बड़ा है. So what it said, 28,000 cases involving over 10 lakh crores have been disposed of even prior to the admission. That is the biggest victory insofar as IBC is concerned. So insofar as fear and greed, these are the two sentiments which drive the stock exchange. All matters of this. So ultimately, if the fear of IBC goes, and that's what insofar as the reverse, that is the purists have one difficulty insofar as this part is concerned. You may be solving the immediate problem which is before you. You are tinkering with the stream of the system. Nobody has gone ahead and said that insofar as this money is concerned, you will put it on in bold, in red, that you will lose all your money if the builder is not sound. And therefore, there are many steps which they could have taken. There is another report which Jyoti shared with me, and I would urge everyone to read that. What was required is that since law commissions and things of that nature, they sit and do it. But insofar as IBC is concerned, there is no great law commission report which is there. There is no in-depth analysis. There is nothing which has been done by people who can understand the macroeconomics. How the interplay of this entire thing which is going on, we can be very happy that we have resolved one or two cases, but that is not important. To being sentimental and being sensitive are two separate things. Resolution and recovery are two separate things. Law and justice are two separate things. But I understand, yes, the law must kneel before justice. Justice has been done insofar as these matters were concerned. These were specific cases. They could have been resolved only because they were at the completion and the fag end. Therefore, we need to understand insofar as the IP professionals are concerned. I'm deeply obliged to Shweta for having invited me. I did not know about this law much. And most of the reading which I have done in the last 1 week is more than what I could have done in the last 6 years of the existence of this law. Thanks for providing me this opportunity. I did not want to sound foolish before such great friends and had to study very hard. So I must admit that. So I've become wiser by reading this, but looking at the fact is that we are still putting band-aids. This is certainly not a very good approach. It is not a comprehensive approach. It is very childish. It is very incorrect. It is very wrong. We must analyze each of these 1,000 cases which have come before, which have been resolved and which have not been resolved. What is the root cause analysis insofar as this is concerned? And the report insofar as the Jyoti shared with me with respect to the report with respect to the housing sector is concerned. I have of late, because of ChatGTP and things of that nature, become very, very fond of data. The data, when I looked at it insofar as if I were to put this data, 75% of the problem is in NCR. NCR is a loosely worded thing, but 75% when I say is that it's all in Noida. Noida, Greater Noida, and those builders, the same builders or their subsets who came to Gurgaon, they created a problem here as well. So therefore, maybe in Mumbai, in the Navi Mumbai side, insofar as this problem is concerned. So I was just reading and looking at the fact that why did it happen? Tu idhar udhar ki baat na kar, bata ki karwan luta kaise? What happened? Now, if I were to look at what happened, because if you look at it, it will not happen in Mumbai, it will not happen in Bangalore, it will not happen in New Delhi. But why would it happen insofar as Noida is concerned? If you look at each of these balance sheets, such intelligent people are sitting over here, they will tell you they forgot the basic principle of debt to equity ratio. They were all playing on debt. There was no equity which was involved. Almost negligible equity in some format or the other would have been there. Noida authority gives you a land for 1,000 crores. You deposit 1,000 crores, pay the stamp duty, get it registered when you pay the installments. The basic principle of law which we used to study was that you cannot sell what you don't have. You have permitted, insofar as the Noida authority is concerned, you have permitted it to sell land without realizing the money. So if you have permitted, then what happens is the FAR cost in Noida would be around about 2,000 rupees, 1,000 rupees, depending upon the area. And the cost of construction would be around about 2,000 to 3,000. In the last 5 years, the cost of construction has almost doubled. So as a result of which, if the home buyer wants that same flat for 2,000 rupees, and if there is a delay of 5 years, so somebody will have to look at it. What have we done? Are we benefiting somebody at the cost of somebody else? If the banks were alone to take a haircut, then ultimately each one of you will pay more interest. I can understand I'm getting old, I will get a pension and I have to depend upon a interest income. But for the young, it will be a burden. So therefore, some kind of a system needs to be there, some kind of a neck of the personal guarantees, personal solvent guarantees process, insofar as today you have created a mess. What happened? First you forgot about insofar as how have these amendments come about. They never thought insofar as the home buyer was concerned. He was not neither a financial creditor nor a operational creditor. What was he? So therefore, this is a problem that which you have created always. So you have to put him in some kind of a category, or you would have said that anybody who does not fall in this category would fall into that category. Then you realized, yaar, ye to home buyer bahut important hai, ghar nahi banega. Then you put him, then you interpreted the law, you stretched it, then you came it by way of an explanation. Explanation only explains, it says what was there already. So each of these amendments go to the Supreme Court, they come back, we clap that what a decision insofar as the Supreme Court is given. But in this entire process, no root cause analysis has been done. Insofar as the biggest achievement of IBC is that it has brought in financial discipline. And if the law was to kneel before justice, and these adjustments were to be made in the spur of a moment and with respect to respective particular cases, then hard cases make bad law. So those principles probably, insofar as the government was concerned, the economic machinery, the RBI, all these people should have put their attention and seen that the discipline which was brought insofar as IBC is concerned, who controls it, from a broader economic perspective, they should have looked at it. The entire, which I saw, was around about 4 lakh houses which are into difficulty, out of which 60% payment would have been made. An average cost comes to around about 1 crore. 4 lakh crores was the entire cost, $50 billion, and we have put the entire system at stake. Out of that 50, 35 would have been recoverable, 15 is the deficit. Sorry for being long in monologue.
Well, I'm informed by the coordinator.
We are thankful to these Greater Noida builders. All of them are having registered offices in Delhi. So some of these cases could be resolved and jurisprudence could develop. अगर सब Greater Noida होते तो अलग अलग बेंच होती और शायद आज के दिन कोई विमर्श नहीं होता.
It's all the will of the providers. और वो होता तो मुझे आप बुलाते ही नहीं.
फिर हम भी आगे होते जाए. ये ऐसा ही ना होता.
ठीक है.
Well,
Anyway, so I thought, let me not be pedantic and give a larger view that what is at stake. It is not a few home buyers. It is the economic system. We don't want to become a Brazil. We don't want to become a Turkey, which is having an inflation of more than 50%. We don't want to become an Argentina, which is having an inflation of 100%. We don't want to be what was faced by Canada today. It is around about 6%. US, it's becoming so very difficult for them to do so. And insofar as this financial discipline of 6% plus minus 4% plus minus 2, RBI has to stick to that for India to grow at 8%, 7 to 8%.
well, I'm informed that we have run out of time. And over to you.
Just one thing, Mr. Mr. Lamba said the question paper has been leaked as well as the answer. So I have a different view. Just taking over your, role for a minute. Now, Mr. Lamba, just one thing. How come, despite, like Jyoti said, Amrapali goes into CIRP, Subate goes into CIRP, Vigneshwara goes into CIRP. What is the model or the outlook of DLF? Because that's one of the most important questions. And since you are here, I think that's the most important question, Jyoti, which should have been put to Mr. Lamba, that what is the model or the outlook or the ideology of DLF that we really haven't seen?
I cannot speak about my company, but it is one thing, and that is financial tools. We have not written more than, I'm constrained not to speak.
No, you're
off the record. It's only because of the fact that we have been financially prudent. We have not bitten more than what we would have chewed. That's the only thing. So ultimately, वही बात है कि जितनी चादर हो उतनी ही पैर फैलाना चाहिए, irrespective of the economy. Spain can get into difficulty, Germany can get into difficulty, Turkey is getting into difficulty, many countries will get into difficulty. So whether it is individual, Pakistan is into difficulty. What India has done is financial prudence. Bangladesh is today on streets. Sri Lanka has gone bankrupt. Pakistan has gone belly up. Nepal is facing the same kind of a difficulty. China, 25% of their GDP comes from real estate. Evergrande and the others, we don't know what they are doing or what they are capable of. There is no transparency. We don't want to go that way.
And in fact, I was reading that the GDP per head in India is higher than the GDP per head in China. So see where we are.
No.
There is a discrepancy.
They are almost 6 times ahead of us.
Oh, I thought recently I was reading a report in 23.
No. China should be around what? Few trillion dollars here or there, you will not catch me. It should be in the vicinity of $19 trillion, and we would be in the vicinity of 4, between 3.75 and 4.
But sir,
That's a major difference.
$1 billion is what the Pakistan is, chasing away, chasing basically from the IMF. And you are keeping a rider of billions. This is too much for them.
So the joke was, Nita Mani was wearing jewelry over Pakistan. But all nations go through those periods. That's not the point. But I thoroughly enjoyed Shweta thanks for giving me an opportunity to read.
And it's good we had an economist amongst us.
No, I'm
See,
not an
no, but it's a very different perspective. Although most of it went above us.
I'm
As lawyers.
I'm not an economist.
But it's
I've never studied economics in my life.
You don't need to study, sir. That's it. That's the beauty.
Have you time for questions?
I am told to stop now. I still had some few questions, but then we ran out of time.
Thank you to all our panelists for their valuable insights. To conclude our conference, I would like to invite Ms. Yashodhara B. Roy, Senior Associate at Hammurabi Solomon Partners, to deliver the concluding remarks. Ma'am, please address the gathering. Yeah. May I please also request to assemble for photograph?
No, it's a pure admission. ठीक है paper bag.
Thank you, sir. Dear ma'am, Ankita, Jyoti sir, and the entire organization team, specifically Pranshu, this was a very wonderful conference that we had at this correct precipice right after the budget session. And with the roadmap that ma'am pointed out in the morning, all the topics that we would have addressed throughout the day, starting with what have been the achievement of IBC so far, what is the lacuna in IBC so far, how Ankita completely dealt with the entire valuation landscape, the different kinds of challenges faced by the valuers, as well as what we understood from that panel, that having a COC backseat drive the entire valuation would actually be the way forward now. Coming to the real estate sector, what I think I would like to combine the real estate sector discussion to one point with the first session, which something that came up that I think Nagesh sir had said that right after the admission, if we have a forensic audit, would that help at all? In that particular case, the entire light of reverse insolvency changes. Therewise, we can understand that which promoter in control, the debtor in control, would help with the project-wise insolvency. So these are various things at time and time again. Yes, these have to be legislated, but more than that, a working paper, a discussion paper is necessitated at this point in time that could be sent out, and not just the IBBI. There, like we have discussed during the valuation sector as well. IBBI cannot be overburdened with just being the particular department. There has to be something for standardization of the valuation as well. So for all of these, we need to have today. It is very important to have one monitoring committee, one working paper, figuring all these different issues out, putting this in place right in this next 6 months before the winter budget session comes up, so that there are realistic changes in the IBC. The first phase is over. We have streamlined several of the issues. Now it is time to address, as Shastri sir had said in the first session, the substantial questions have to be answered, whether it in terms of the definition of the group insolvency, whether it in terms of looking outwards, like Devra sir had said that look at BVI, look at Hong Kong, how they are looking at their investigation, their insolvency, and how even though they are tax havens, the insolvency regime is very strong. That is exactly where India today, the IBC today, maybe we have given a structure. We have come out of Sika and Bifur, but now we have to strengthen it further and furthermore. Maybe we have to look into the fact that how ma'am had rightly said, 29A is no longer, it's obsolete now. If we are looking at PPIRP, maybe we should bring it all back in and let go of 29A. We shouldn't be, on two boats at the same time. So these are my 2 bits on this entire conference today. It was a very wonderful conference, right at the, as I said, at the perfect precipice of the time. Thank you so much.
Thank you, Ms. Yashodhara, for those thoughtful concluding remarks. Ladies and gentlemen, this brings us to the end of our conference. Thank you all for your participation and contributions to today's discussions. We hope you found the session innovative and inspiring.